Just press the let's go live button. So we better wait and make sure the stream will fire up all across these fruited plain of the internet before we go ahead and get started, because sometimes the tubes get clogged over the weekends and then we got to blow them out before the informational conveyance starts. Are the tubes working? It looks like they are. Let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Donald Trump's trial date. Would you believe it? It's going to be happening pretty soon. We know that there are 11.5 million documents that amount to 8.5 Washington monuments that we've talked about here before. And I want to go through it again in context, because we now have a trial that is going to be scheduled for March 4th, 2024, which is like nuts. All right. The government asked for originally a January date, and the defense asked for a 2026 date. And so from January 2024 to 2026, what does the judge do? Definitely doesn't split it down the middle. Just says, well, we'll give you a couple extra months defense, and we'll move it from January to March. It's insane. We're going to go through the trial order and see exactly what the judge articulated here. And this might actually stick. If she's going to dig her heels in on this one, then that's where we'll stay. Now, we're also going to jump into what actually happened at the hearing today, courtesy of Brandi Buchmann. She does some reporting on this, and she did a live tweet thread over this. I did create a calendar here and assemble some of the most important dates so we can put this in context. What's coming up first? Iowa, South Carolina, January 6th trial, Super Tuesday, classified docs trial. Then what? And we'll go through all that in a little bit further detail. Then we've got some reaction. Actually, ABC says, yeah, even some lawyers are confused about this and why they're doing it this way, but it is still all legitimate though, of course. And then we've got this woman, Donna Brazil, who is just in this state of cognitive dissonance. It's nuts. But she's saying that the Republicans politicizing these prosecutions is reprehensible. How dare we politicize their corrupt political process? How dare we do that? It's a wild argument from her. And then, of course, Alina Habba, because, brilliant legal analysis. That's why. That'll all be coming up in the first segment. Then in our second segment, we want to get an update on this Mark Meadows situation, because he had another hearing today. We were busy today, baby. And so Mark Meadows was in federal court, and I don't know where it ended because he was coming back after lunch for some additional cross-examination. But the story is he took the stand this morning, and people really weren't expecting this. There was a couple witnesses that testified in federal court, and Mark Meadows, the president's former chief of staff, actually took the stand. People are going, wow, that's pretty interesting, because that opens him up to cross-examination. Now, a lot of people were paying attention to what Judge Chutkan was doing, and so he didn't have a real good live tweet thread from anybody out there, because this is a court where you couldn't even have a viewing room, or there were no phones, so people couldn't live tweet it. So we've got a couple articles that I pulled up, along with this woman who was there, Anna Bauer, who does some reporting on Twitter. So we'll get our heads around what happened with the Meadows hearing. And then I've got this clip from Jen Psaki and this guy, all talking about how Republicans want to hide this under the radar like vampires, because they're like vampires or something. Yeah, Jen Psaki's coming up. Then we've got this other new complaint. We've got a Florida man who is filing to remove Donald Trump from the 2024 dockets. And we've followed this one along. I feel like we're following the bouncing ball, one right after another. We had the theory come out from the law professors. Then we have them sending letters to secretaries of states. Then we've got Judge Ludwig, who decides this should be talked about on MSNBC. Then we got Asa Hutchinson over from the GOP, who brings this out at a national debate. And then lo and behold, we've got lawsuits trying to get Trump off of the ballots. That's taking place right now. This guy, who's a Florida man, Lawrence Caplan, is the person who actually filed it. So I'll go through that here. We'll go through that here today and take a look at it. Not a huge lawsuit, but it's literally just following the bouncing ball. So we'll go through that. Then in our final segment, Pretty interesting discoveries came out over the weekend. More evidence that the White House colluded with Jack Smith, the special counsel. Who'd have thunk? Now, they keep telling us that the Justice Department is always so arm's length away from everybody else. No, they didn't collude with the Hunter Biden lawyers to create some garbage deal. No, they didn't collude with Jack Smith to have Joe Biden's chief opponent prosecuted. No, that never happened. Well, turns out it did. We've got some reports from the New York Post and others showing that these two people had some meetings at the White House. The visitors' logs show that this woman, whose name is Caroline Saba, is on record meeting with Jay Bratt, who is the lead Justice Department prosecutor, who's a part of Jack Smith's team. So what are these two people meeting together for? Collusion. That's why. We've also got a news story. I believe this came over from maybe the Washington Examiner. They said that the DOJ was also intervening to protect David Weiss. So when Congress started to investigate what was happening when the whistleblowers spoke out, Congress got involved. The DOJ protected David Weiss. All of this stuff is disgusting and, of course, impeachable. The question is, will the Republicans do it or any of it at all? Reaction from Kevin McCarthy, Marjorie Taylor Greene, and Byron Donalds, all in the House, saying, look, we're getting there. Things are getting closer. Time will tell and see what the Republicans do. But that, my friends, is the agenda for the day. And we've got some serious business to get to. I am grateful that you are joining us on this lovely Monday. We had a members-only stream this morning and a great Saturday stream. Man, we talked about Harrison Floyd, who was detained in Georgia. We talked about that on Saturday. I got a video on that one coming out. And then this morning, we talked about the alternate electors that the Democrats used back in 1960 in Hawaii. Ran through those documents, and that was a fun little discovery as well for our members this morning. And of course, if you'd like to join as a member, we'd love to have you. Watchingthewatchers.locals.com is the place to join us. We do member-only streams in the morning, Saturday shows. We've got a movie night coming up. This is our new movie poster. Thank you, John McGarvey, for this one. And I like this one because it reminds me of lasers, because there are lasers, and who doesn't like lasers? September 2nd coming up with our nice new logo. Woo, looks good. And we've got discussion starting 6 p.m. Eastern time. We're watching V for Vendetta. So if you haven't seen that, that's what we'll be talking about this weekend, coming up this weekend, actually. So that's going to be fun. If you haven't seen it, see it. We've got this one. Also, our website, robertgovea.com, is our brand new website. And you can sign up for our daily newsletter over there. Just click this button, sign up for it. You'll get the summary of everything we talk about here delivered to your inbox every morning. And that way you don't miss anything in case YouTube decides to do something squirrely. We stay connected. You can also click this reports button and stay connected to all the different reports that are here listed under the reports section. That's our Pinocchio Joe thumbnail. And you've got a various report of all the things that we talk about in the video. If you're not capable of watching the thing in full, robertgovea.com. We appreciate you following us and joining us over there. And now, before we get into it, we've got to talk about our friends over at Field of Greens, because this is where we can get healthy and fortified. And one way we want to lose some of those leftover pandemic pounds is by going to Field of Greens, because look, there's a lot of other things going on out there. A lot of other ads for weight loss pills, fad diets, all this stuff. You see them all over the TVs. But we've all been there. We've all done that. We've all tried them, and they just don't work. But you know what does? Eating healthy. Go figure. Especially 5 healthy servings of fruits and vegetables every day. You do that and the weight would probably just fall right off. But look, vegetables, not a fan. And fruit, who's got time to prepare that every day? I don't. Instead, let's talk about Field of Greens. Delicious. Now, Field of Greens is a science-backed formula, specific fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you can burn calories faster and lose weight the healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor takes one look at you and says, woo, woo, you are looking good. Whatever you're doing, keep it up. And so let's get you started. Head on over to fieldofgreens.com. Don't forget to use code Robert when you check out. That way you can save 15% off when you are at your exit cart, and you'll save and you'll get a bunch of good stuff. And let's not forget, the vegetables want to be eaten. That's why they're here. And my friends, a quick note on our sponsors here. So I'm very grateful for our sponsors, and something we've been talking about on Locals, a little bit more extensively, is some of the back end of what we're trying to do here on this channel to make sure that we have infrastructure so that we are anti-fragile, so that if something happens, like this channel was demonetized for 9 months after January 6th. It was a big, big problem. So we're trying to build some infrastructure to make sure that doesn't happen again. So if some other shenanigans happen in 2024, as the election comes up, that we don't need to rely on any one source to provide for what we do here. And our team is growing. We've now got 5 people on board to help with the editing, the shorts, all of the video production and all of that stuff. And so it's turning into this thing, and we are just getting started. We really want to kind of beef this up. We've got interviews that we're recording and a bunch of other stuff on the docket. And so we are going to be experimenting with some other sponsors here. And I'm very fortunate that a couple people have reached out, one of which is this company called Aura. And aura.com/Robert Govea is another one. Now, I'm not going to do a read for them today because they're not interested in the live stream stuff. Okay, they just want some content in the segments that we produce and put out. And so when we go through the live streams, I just want to tell you this, how this works mechanically, is that I'm not going to do a read. What we're going to have here today for this and in the future for these reads, and a lot of these are just going to be kind of experiments, right? They're just dabbling their toe in the water here. And so I encourage you to support them, but they're only interested in the segments, not the live stuff. And so we're going to exercise live stream privilege for these reads when we go through this, and we're just going to fast forward through them. Okay, so I'm going to pause in the segment. So we're going to do it like on the third one. We'll try it today. I'm just going to pause. There'll be a segue, and we'll just clip it in there for the segments that we release later. All right. And so that's what's going to be happening now. And so we're going to have live stream privilege. We're not going to go through those today because they have some pretty, they want guidelines. They want us to pin a comment and put something in the description and make sure it's within the first 5 minutes and all this stuff. So that's what we're going to do. But I just wanted to let you know that that's what's happening. And I really appreciate your support. We're trying to be robust so that we've got an email system, a website. So if anything happens, we can keep this train on the tracks. And so I just wanted to explain this. Obviously, I'm not going to do this every day, but I appreciate that. Okay, so that's what's going to be happening today if you're curious. Now, with all that out of the way, a little bit of a business update there. Thanks for indulging me on that. Let's get to it. Judge Chutkan in the Donald Trump January 6th prosecution set a pretty insane trial date, March 4th, 2024. We're all sitting here scratching our heads saying, that's pretty soon. That's like right around the primaries of the 2024 election. In fact, it's one day before the primaries, which are going to be taking place on Super Tuesday on March 5th. Isn't that convenient? So March 4th is going to be the trial in DC. Super Tuesday, when many states around this country are voting, going to be the day afterwards. Very convenient timing. Now, Judge Chutkan released a trial order. We're going to go through that. And we're also going to see what happened in court because Trump's lawyer put up a pretty big fight here in court today saying this was outrageous, insane, unreasonable, because there's no way that Donald Trump's defense team can possibly prepare in this short amount of time. Remember that the government wanted this trial to happen even sooner. They asked for a January date. I was saying it was actually a December date because that's when they wanted jury selection to start. But the trial with opening arguments, they wanted it to start January 2024. January 2024, from their perspective, Trump asked for 2026. Why? Because they have 11.5 million documents in the initial batch of discovery that they have to review. It's an insane amount of documents, really without precedent. And here is what it looks like on a scale. If you were to print out all 11.5 million pages of documents and stack them up, it would be 8.5 Washington monuments. This is the Washington Monument. You've been to Washington, D.C. or seen pictures of it. It's that giant tall building. It's huge. 555 feet. If you stacked all of the papers up, that's just one Washington Monument. Trump has 8.5 of them, all right, in physical paper documents. That doesn't include audio recordings, video recordings, spreadsheets, documents that don't have pagination, all sorts of technical readouts, right, all the other things. I would imagine there's books in there, treatises in there, they're referencing all sorts of insane things. You've got, that's just what they're giving to Trump in their initial production. Remember that in a criminal case or any case, you have discovery. They've got to exchange information. And it never, ever, ever is the case that the person who receives the information says, oh, perfect, that's everything I needed, thank you. We'll get to work and look at this. We don't need anything else, though. Have a nice day. Never. You always say, nope, you're missing this, you're missing this. I've got questions about this. I want to interview that guy. I want to do this, that, and the other thing. So Trump's people would come back on this and they would say, all right, you've got 11 and a half. Well, you reference this person and who's this and what agency said that and where'd this report come from? I need all of that. So 11 million, if you extrapolate that, let's say, you get one hint in the original batch that cues you off to 5 additional pages of whatever it is, which is probably a low estimate. 5 pages per hint, and you're looking at like 50 million pages of documents when you're requesting supplemental discovery and you go round and around and around. It's nuts. There's really no precedent for this. And this is why Trump's defense put up a fight. And here's what they argued in their motion. They said, this is ridiculous, Your Honor. 11.5 million pages is insane. There was another case in this country called Walmart versus Visa. It took 7 years to litigate that case, 7 years. And they want this happening basically within 8 months, give or take. 7 years, and that involved 5 million pages of documents. It's an insane amount. So if they wanted trial to happen before January, that would have been 100,000 pages per day. That is reading. So you have to think about lawyers reading all of this. Like, this is lawyers doing this. That is the entirety of War and Peace, cover to cover, 78 times a day, every day from now until jury selection. Now, the judge gave them an additional 2 months, right? So it was supposed to be January. Their calculations were for January, but she said, no, you're right. You need a little more time. So they bumped it out. So I don't know how many times that is now. So now that means you've got to read it, 68 times a day? I don't know. We're not going to do the math here, but it's crazy. That's just reading it, not analyzing it, organizing it, integrating it. So let's say Trump hired 78 lawyers. They would have to read Tolstoy's book once per day, every day until jury selection. You need 78 lawyers reading it one time, the entire book per day, every day from now until jury selection. 78 lawyers. Yeah, 7 days a week. You'd have no break at all. Nonstop. And that's just reading it. So then you got to organize it. And then you're going to have questions about it, right? They're all going to have questions. Hey, who is this? What's this on page 5? I got a question. Hey, I want to interview this dude on page 35. Hey, what's this question about this character? Nonstop. So obviously that's insane. Now they gave them, to be fair to this judge, by pushing it back a little bit, it's probably not 78 lawyers every day reading the book. It's probably like 70, maybe 70, 65. I don't know. Because they got another 2 months. Do the math. Probably not. It's actually probably like 75, right? It's a lot. So if you stack it all up, it would stretch 5,000 feet into the sky. Here's what it looks like. And that's just the documents. But the government still has more materials. They're going to have more stuff. And they cite it all, right? More stuff is coming. They're going to continue to produce the defense. This is more material. This is just their batch. Trump's people have not even asked for anything yet. So the judge took a look at all these numbers and considered Walmart versus Visa and their 7 years of litigation. And she decided to do the following. Judge Chutkan issues the pretrial order. With all of that being said, very short order, couple pages long, 3 pages, filed against, in the case of the District Court, United States of America versus Donald Trump. They say, trial is going to begin on March 4th at 9:30 a.m., 2024. All pretrial motions, excluding motions in limine, which are the preliminary motions that you file kind of last minute to preclude somebody from testifying or to keep certain evidence in or out. We cover a lot of them here. Shall be filed on or before October 9th. Oppositions due by the 23rd of October. Replies due by November. Any character evidence no later than December 4th. Government shall provide notice if it intends to offer it. Motions in limine and suppression motions shall be filed on or before December 27th. Man, right in the holiday season, Shall be oppositions by January 9th, replies by January 22nd. Now, voir dire is going to start. Oh, this is curious. Yeah, so they're going to start jury selection January 15th, but then the trial's not going to start. Oh, no, I'm sorry. This is when their questions are due. Okay. So counsel shall jointly submit both a short narrative and then file their proposed jury instructions by that date. I was going to see, when does jury selection start? Okay, there you go. When? All right, so here it says, to the extent that the parties seek to use pattern jury instructions from the current Red Book, let us know. The government's under ongoing obligation to disclose exculpatory information. This is your Brady material. If the government knows anything that is tending to prove Trump's innocence, then they've got to disclose that. On or before February 12th, expert witnesses disclosed by December 11th, exhibits filed with replies no later than January 9th, witnesses exchanged final lists by February 19th, and then jury selection procedures, they'll figure that out at a later date. So jury selection at a later date. Okay, so very, very fast, right? A lot of this is standard stuff, but it's just happening very quickly, very compressed time frame. And this is not something that the Trump team is happy about. We know that the Democrats, in my opinion, are largely doing this to try to squeeze it in before the election, because this is what they're going to parlay into an excuse to keep Trump off the ballot, right? Once he's a convicted felon, especially on the J6 case, then they're going to say he's guilty of insurrection, and that's going to justify removal from the ballot. They're going to say he is not qualified, just as though he's under the age of 35, or just as though he's not a naturalized, natural-born citizen. Insurrection just disqualifies him, and the felony conviction will supplement that. So we know that's what the judge ordered. Let's take a look at how this all went down in court. And as usual, we like to check in around Twitter. This is Brandi Buchmann. We've referenced her many times before. She covered a lot of the Proud Boys trial, and now she is apparently working over at Law Crime News. Brandi Buchmann on Twitter if you want a good follow for some court journos. Here's what she says. Out of D.C., Judge Chutkan coming out onto the bench. All rise. Oh, gosh. All right. Please be seated. Judge walks over to the bench, and Chutkan's wearing a bright blouse underneath her black robe. We look over at the government's prosecutor's desk. Guess who's there? Molly Gaston. Now, for the government, looks like it's just her, but for the defense, we've got a couple of other lawyers. John Lauro, Todd Blanche, and Greg Singer, all here for Donald Trump. Trump is not in attendance. His presence was waived. So Judge Chutkan comes out. She says, all right, good morning, everybody. Now, we're here today on a trial setting conference, but before we jump into the trial setting, I want to discuss Trump's motion to exclude 25 days between Trump's initial appearance on 8/3. Remember, this was an early August case under the speedy trial rule. And this is Trump saying, we don't need that time. We're not in any hurry here. Okay, so don't count the days. Don't start the clock against us and tick those days off for speedy trial calculations. We don't need them. We waive them. We just throw those in the garbage. And they say, please exclude them from our calculations. The judge says, well, you guys, a defendant's trial, it must occur within 70 days from the date of the initial appearance. But we can exclude some days lost to delay. And she says, well, taking this into account and all the reasonable time between the arraignment and this hearing, I do find that approximately 25 days will be excluded, saying that there were some delays and taking into account, so she waived some time. Okay. We're done with that issue. All right, let's get, any objections? Then no, fine, 25, okay, whatever. All right, now, with that out of the way, she says, now we're here for a bigger reason today. Got to set trial in this case. Says, all right, government, you're proposing here today a January 2nd, 2024 trial date. Is that right? Yeah. And you say you want voir dire, jury selection, that you want that to begin in December, right? Yeah. And Mr. Trump defense team, let me be clear, you guys are asking for April 2026. Is that also true? Yes, that's true, Your Honor. She says, well, you know, these proposals are obviously very far apart. And for reasons I'll discuss shortly here, neither one of them are acceptable. She opens up her book and she's dragging out a memo. Looks like she's got some case law. Everybody goes, oh, great. She says the Speedy Trial Act case law, it provides that the appropriate judicial officer at the earliest practicable time shall, in consultation with the government, set a trial for a certain day to ensure a speedy trial. And so she's reading through the rules. She says factors that may influence a speedy trial: complexity of the case, good one on this one, continuity of counsel concerns, continuity of counsel, like is a counsel going to be on the case for so long that they have to change or whatever. Also, concerns for effective preparation. Like, remember, the government has been investigating this case since January 6th. They've had years to prepare this case. Does Trump get any of that amount of time since this was just filed in August? Judge says, well, and given those factors that we've just analyzed, says Donald Trump, like any defendant, will have to make the trial date work regardless of his schedule. So she says, I don't care if he's got campaign events. I don't care what he's doing. Just like if this case involved a professional athlete, for example, it would be inappropriate to set a trial date based on her game schedule, which is obviously true. And I like how she used the female pronoun there. In her mind, it's a WNBA player. It's like, obviously, why would you care about if they're in a game or not? Who cares? Obviously. But if it's another athlete that people actually care about, then maybe she would want to care. So it's interesting. Anyways, that's just me inserting that. But so she's saying, look, if you're a doctor and you're in surgery, if you're a teacher and you've got classes to teach, if you're a plumber and you've got a big job, we don't care. We're the courts. Show up here. She says, and look, this is like a little bit different. Donald Trump is running for president, which is a little bit different than a professional athlete. Just to be clear on this, right? One, the position that he's running for implicates the Justice Department. Okay, one of the things he's running to do is to reform the Justice Department. So part of the political process is necessarily to comment on what I would argue is an illegitimate, corrupt Justice Department, which includes this court and what we're seeing out of DC. Sorry, but it's true. And so this has to be something that he can comment on. Otherwise, his free speech rights are being trampled all over, and the political process that we're due as American citizens is non-existent. So to compare it to just a professional athlete that doesn't have any of those same factors or any of those same considerations is asinine, right? It's just a dumb comparison because it's not the same. And I know these people want to make it the same, but it just isn't. There are additional complexities that they're going to have to deal with whether they like it or not at some point. And they're going to keep playing this thing that nobody's above the law. We made this point before. The president literally is above the law. That's why he has the pardon power. That's why, in my opinion, he's got the opinion power, the opinion clause power, the commander-in-chief power, declassification power, all of those different powers. So it's a big deal. Now, the judge continues, living in fantasy land, saying, public has an interest in a fair, timely, and fair justice, which is true. We would like to see some fair justice here. Delay can prejudice, and it is not an uncommon defense tactic. That's true. We delay all the time, all the time. Very true. Doesn't make it illegitimate or illegal. As trial lengthens, witnesses can become unavailable or memory jeopardized. That's true, yeah. But unfortunately for the government in this case, they have 11.5 million pages of documents. Judge says, I looked at other case law. Says, you know, in U.S. versus Burton, D.C. Circuit, counsel is not entitled to unlimited prep time, which is, again, not what they're asking for. Counsel is entitled to reasonable prep time. So she's citing a comparison case. It's just like when you go to house shopping or something. Not that I've ever really done that. But, you're looking, you say, this one's got a pool, this one doesn't have a pool. What do they cost? This one's got a 2-car garage, this one has a 3-car garage. This is what we do in the law. We take different cases and say, well, what's happening here? So my question in U.S. versus Burton, which we don't have, were there 11.5 million pages of documents in that one, Judge? How about in this one, U.S. versus Cronick? SCOTUS held. They said neither PD of time the government spent investigating the case, nor neither the period of time the government spent investigating the case. So it doesn't matter if the January 6th investigation took 5 years. Trump doesn't get 5 years. And the number of docs that the agents reviewed during the probe is relevant to the question of whether a competent lawyer could prepare to defend the case. So what they're saying is they want to separate these two things out. And this is pretty common in the law. They don't want to set a threshold to say, well, you can only government disclose 1,000 pages of documents for DUIs, 5,000 pages for aggravated assaults, and 10,000 pages for murder cases. They're not going to set thresholds. Or if this case has 200 documents, that the defense should prepare for it in 2 days, but if it's got 1,000 documents, they get 5. Like, they're not going to do that game. So they're saying the Supreme Court has said that you don't automatically just get more time because of the number of documents, or automatically get more time because of the length of time that they used. But it is what is reasonable for the defense to prepare and defend the case, which makes sense logically. Otherwise, you're going to have micromanaging of the cases. But again, in Cronick, my question is, was there 11.5 million pages for the defense? Let's see where this judge takes us. The judge says, all right, well, look, and while I'm talking about this, we're also aware that Donald Trump has other indictments and other matters, totally legitimate, of course, and says that Todd Blanche here represents Trump in New York and Florida. And he says that Blanche is going to be here in D.C., so he's very familiar with all of these. He says, Judge says, I'm going to start addressing the timing of the other cases. And it sounds like Trump's lawyer says, Your Honor, before we start addressing those other cases, I just want to be clear about this, okay? The median time for a conspiracy case in the United States is 29.4 months, okay? Just so we're clear about this. 29.4. You're giving us 7 months to do our case. 29.4 to 7 months. That was from commencement to sentencing, says the government, not trial. Sentencing in this court takes 90 days or more from the verdict. So that statistic is a bit misleading. And so we saw this come up. So it's like, so what? So subtract 90 days off 29.4 months. So subtract 3 months. Great. Now what are you at? 26 months? Neat. Still over 2 years. Not anywhere close to 7 months. If the government wants. Sure, take off 90 days for sentencing so your statistics aren't misleading anymore. But the judge continues. She says, all right, well, I've also noted, I've read everything. I'm looking through Trump's motion. I see that the cases that were cited by the defense, you guys cited this, they all involved 6 and 17 co-defendants. And there's no co-defendants in this case. So what she's doing now is she's saying that your house has a bigger backyard and this one doesn't. So that's why you don't need as much space over here. Says you haven't identified any case where the defendant was given over 2 years between the indictment and the trial. So she's like, I want to see a specific case. and there's no co-defendants in this case. She says, examples used by the defense here weren't quite accurate either because we had COVID. Oh, yeah, because of the limitations of COVID. So they used COVID to rig the election, and now they're using COVID to rig the judiciary. Isn't that fun? Oh, well, the reason it took so long back then was because COVID and things were slow. But we're going faster now, so now we can go very fast. She says, Trump's people argue that it needs years to review 11.5 million pages in discovery. She says, but the government has already said that a lot of that is duplicative. So it's like you've got 2 copies of that. But the government contends that 65% of the materials that Trump functionally has access to are duplicative. So why did they include duplicates? 65% of that are duplicates. And 25% are from entities associated with Trump and other documents. So they say, well, we rounded up these documents from Trump's organizations. And so he should automatically know what we scraped out of him. And he should just automatically know that the duplicate pages are actually duplicates. He should just trust us. And he should just not look at half of them. He should just not look at 65% of the materials because they're just dupes. Which is insane, okay? That's like actually malpractice for a defense attorney to not look at 65% of the materials and just presume they're duplicates. In thousands of pages, they're from Trump entities, and he would have already had access to those, so he doesn't need time for those. So the judge says, okay, Molly, the prosecutor, can you address discovery production notes in your recent motion? How much discovery did Trump already have access to? So they basically are saying that Trump should have been defending himself against criminal charges in a case that hasn't been charged yet. How much of the discovery did Trump already have access to, asked the judge, including items at the National Archives? Molly from the DOJ says, at this point, discovery is now substantially complete, whatever that means. We made a 5th production last night. We are at 12.8 million pages generally, 12.8 million. So it's way more than 11.5. So that's like, we're at like now, I don't know, 10 and a half Washington monuments. Oh my gosh. We're in double-digit Washington monument territory of discovery. But she says, as we described, the number of pages isn't the best metric because we probably have a bunch of spreadsheets and a bunch of things that have like columns that go out into infinity, you know? So if you actually printed out the 1,000 page spreadsheet with columns that go all the way out to XXYYZZ, then you're going to have just this smorgasbord that you'll just dump out of your printer. Your printer is going to be printing all this. So she says, just forget it. Number of pages isn't the best metric, but more than 3 million pages are stuff that we scraped from Trump's campaign, which still a lawyer needs to review. So somebody needs to review whatever those documents are. And PACs. There are millions of pages from the Secret Service. Got to go through those. 102,000 pages from the National Archives. Definitely got to look at those. And the judge says, and these would have been reviewed by Trump's counsel for privilege before they were turned over. That's correct. And she says, what's in the other 5 million pages that we're really talking about? Well, there are things like every grand jury transcript in this case up to the indictment and the accompanying exhibits that the defendant has already. It says there are a lot of reproductions in these millions of pages. Same thing true with witness interviews. We got a bunch of duplicates in there. And judge says, yeah, that's what I was going to ask. How much of the discovery could be categorized as witness statements and notes? Molly says, well, give me a minute. She's like, great. Yeah, I'll give you whatever numbers you need to justify this garbage ruling. Flipping through some papers, Chutkan's taking notes. She says, hold on a minute. It's 58,000 pages are from witness interview folders, and that includes transcripts. Most of them were audio recorded. So the defense has been provided with audio recordings and transcripts for convenience of review and all the exhibits used in those reviews. All right? There's the audio. So, and you want to listen to those too. You don't want to just read it because you can't get all of the tonality in a written thing. And sometimes you'll hear things that are not written. So you've got to listen to that. So 58,000 pages plus all of the time to listen to those in audio format, and then probably read it again. But they said the judge is going to try to preclude them as something that matters. Says those were presented in an organized fashion. And for those of you who are not familiar with Molly Gaston from the DOJ, she is thrilled with her capabilities as a prosecutor, which includes sticky notes, highlighters, paper clips, push pins, and she very much likes to keep things nice and tidy in document fashion, which I appreciate. That's great. But I don't give a crap about that if I'm a defense lawyer and it's coming from a prosecutor. Thanks, Molly. Nobody cares on the defense. But she keeps bringing it up. She says, judge, though, like they're really sticky, like a lot of sticky notes on them. They include the transcript of either grand jury testimony or interview, agent notes, it was in an interview, and then the exhibits associated in any interview report of the interview. It's like all organized. How much of this material is defense created? Like tweets. How much of your 11, 12 million pages are tweets? Well, it says open source would include publicly available litigation. So not sure I have a breakdown of his tweets, but I could get it for you. She says, now forget about the tweets. You said at least 25, judge speaking, you said at least a fourth of the first production and 20% of the second production. They came from entities associated with Trump. You mentioned a PAC. What else? She's digging. What else can I say he's already got access to? Well, there's the defendant's campaign, Trump, a few PACs that we scraped through. In terms of open source materials, she's grasping here, including campaign statements, tweets, True Social posts. It's about 27,000 pages, Judge. And she's like, oh man, I was hoping that was a much bigger number. Like, she's like, I was looking like a ballpark of like millions, not 27,000, like millions. So I could say Trump already had all that crap. Gaston continues, Molly, she says, Your Honor, key documents are 47,000 pages, and that includes all the case agent summary testimony, pretty important stuff, exhibits introed through her to grand jury, includes things like transcripts, witness testimony, all of it. It's a file that's essentially an annotation of the indictment. And that's almost 300 different docs that are labeled and named according to the paragraph of the indictment that they support. So it's essentially a roadmap to our case, Your Honor, which is, I'm sure she feels great about that. It's like, Molly, put that on your refrigerator at home. Okay, that's neat. Hang it up, bring your parents over and your other prosecutor friends, and you can all look at your little mind map. Okay, I'm a huge mind map fan. I love road maps and mind maps and all this stuff. Okay, I'm a big fan. In fact, I'd like to see it. Of course, we'll see it come out here. But as a defense attorney, and from our perspective, your roadmap to your prosecution is irrelevant to us. It's insane that this is even being discussed. It's like the defense attorney has got to be laughing right now. He's like, I don't give a crap about your roadmap. Now, do you think they're going to follow it? Like you're giving the defense all your best materials going to the defense attorney? It's like a joke. Gaston also notes how all of this is in a nice searchable database for Trump to review. The judge says, well, this is really a great presentation. I love this. Fantastic. This has answered most of my questions about discovery. Sounds like discovery is substantially complete. And she says, I just absolutely love how highly organized it is. Your sticky notes are outstanding. You've done a great job, Molly. Sit down. Molly's like, ooh, yay. Judge likes me. The judge says, okay, I'll note now that many years ago, when I was trying a murder and conspiracy case in Superior Court, we got witness names on the date of trial, is what she says. Right, now here we go. And testimony in grand jury sometimes after a witness testified. Rules here provide far more disclosure. So she's talking about her time as a prosecutor. When the prosecutor, when she was trying murder cases, presumably this is her talking about her being a prosecutor, we got witness names on the date of trial. So she's saying, I got to prepare very fast. Making the point that they go quickly, so you can go quickly. Rules here provide for far more disclosure. And sometimes I don't get evidence until it comes out. Okay, so stuff just happens fast. I think it's the point she's trying to make. In this case, we have far more disclosure than even I had, right? Things were bad when I was doing it, but now it's a lot better. The manner in which the discovery has been organized by the government, she bit on it, okay? The government threw this at her and she bit on it. Molly, well done. Those highlighters, man. The government has made a considerable effort to expedite review, certainly beyond their normal obligations. Yeah, the government went above and beyond. There's sticky notes, highlighters all over the place. Prosecutor did a great job, gave the judge exactly what the judge needed to say that you don't actually need to review anything because the government, the people who are prosecuting you, they reviewed it for you and they organized it for you to show you how they're prosecuting you, so you don't even need to read the evidence. And says, so it sounds like it's all very organized. So she says, okay, Mr. Defense, what's your problem? Why isn't this enough time, Lauro? Lauro is fired up. Okay, I can't even imagine. I'm fired up right now. She says, Brandi says, Lauro is coming in hot, which I can't even imagine, man. Because it's these two people are talking about their highlighters, honestly. About 11.5 million pages. A small portion of everything we just read through, 27,000, 57,000 pages, a small tiny dent in the max amount of the documents is from actually Trump's. The 65%, it was just duplication, and it's all nice and organized with the roadmap. So the defense is like, probably going to be charged with murder in the courtroom, any minute. Doesn't cross that line, fortunately, but his voice is raised a bit. He says, Your Honor, President Trump is here as a part of a show trial. We have to do our job as defense lawyers. For a federal prosecutor to suggest that we could go to trial in 4 months, which is what their original request was, is not only absurd, but it is a violation of an oath to justice, Lauro says. Voice is booming. Raged. He's absolutely right about this. It should be misconduct, right? If we lived in a society where prosecutors cared about justice, unfortunately we don't. And I hate to, burst that bubble for anybody out there who still thinks differently. Then this would never happen. A prosecutor would never do this. And every single person who's involved in this case, I would imagine that every prosecutor who's even watching this, who's being honest with themselves, says this is insane, okay? 11.5 million pages. Prosecutors don't even want to read a 50-page police report, for crying out loud. So 11.5 million pages, they know what this is. This game of patty cake back and forth between the judge and this prosecutor, literally talking about organization. 11.5 million documents versus being organized by the government. It's insane. It's outrageous. So he should be upset. The judge says, hey there, John. Let's take the temperature down here a notch, okay? Defense Lauro says, Your Honor, Trump stands before you here today an innocent man. He's entitled to the Sixth Amendment, which is right to counsel. He's entitled to counsel that can prepare adequately. What this case means, we're talking about 9 terabytes of information. I have to go through it. I have to sort it by more than 250 witnesses. I need to think about corroborative material. For the government to suggest that I can do that in 4 months is an outrage to justice. Not once have they talked about justice. They can give me key documents in this case, and that's very kind of them. Judge stops him. Up. You're getting a little bit too preachy over there, defense attorney. I'm going to need you to take the temperature down. Her voice is even and calm. She says, Trump is not like every other defendant, given access to his lawyers and resources. Okay, so now Trump, this is incredible. So now Trump has privilege, so he can deal, like she's justifying his he's a privileged person. He's got more resources, so he can read faster. His lawyers can read Tolstoy faster than other lawyers. He just needs to get 78 of them. And given that much of this has already been reviewed by Trump or his team and turned over, it can speed up review. Lauro says, Your Honor, we as criminal defense lawyers have not had access to what is in the National Archives or the Secret Service. But she says, but some of that material is not new to you. Says, how is it not new to him? Judge says, because he's saying, like, anything that comes from them is new to us. Anything that's in the government's file, I don't care where they got it. They could have downloaded it from Trump's cell phone. I don't care. It's new. So some of these statements, this is the judge, are of your client's own creation. You personally, it may be new to you, but this material that has been reviewed at least by privilege, and some are statements of your client and materials created by your client or entities associated to him. So that's not brand new information, is it? Lauro says, of course it is. And he's absolutely right about that. Because it's from the government. It's all from the government. It's not like Trump gave it to them. This is called chain of custody. It's the same reason we question what the government does when they take the blood out of your body and do something with it. We don't just say, oh, well, whatever they came up with is like a reasonable thing. And if they give it because it was our blood, like we don't need to defend against it or something, since we already know what's in it or something. And since they took it and assembled it and did some analysis on it, that they're done. We're done. Oh, well, I guess the blood came from us, so we should just accept it when they test it. They took these documents and assembled it, and the judge just says, well, you've already kind of seen it, haven't you? Absolutely not. Says there's a lot you may personally need to eyeball, this is the judge, of 11 million pages, but you at the first cut, you personally are not going to review 12 million pages. Obviously not. It's impossible. Some of those documents are going to be reviewed electronically. Lauro says, Your Honor, no documents get reviewed electronically. We can do searches for it that way, but we're not going to do that. He's telling Chutkan to explain the file searches. He says, I like to be prepared for trial. I like to get my exhibits open and all the things. He says, look, Your Honor, if we were a big corporation in America where the only thing at stake is money, no one would even blink an eye for a 2-year delay. But this man's freedom is at stake. He's very emotional. Judge says, I understand, but you're not getting 2 more years. This is not going to trial in 2026. Says the grand jury investigation has been ongoing for more than a year. Which makes a good point. So why would the trial happen in less than a year, in 7 months? Defense says, Your Honor, we can't be charged or hindered because we couldn't do an investigation during the grand jury. What do you want us to do? Chutkan rests her head on her hand for a very brief moment as she listens to Lauro. Oh, gosh, she says, oh, gosh, this Trump defense lawyer. Ugh. She says, I'm asking you to review what's necessary in this case. I'm well acquainted with Gideon and Trump's 6th Amendment rights. I intend to ensure he gets it, but I'm not going to give you, this case is not going to trial in 2026. And I'd like you to know that given the rhetoric in your response, realistically, how much time it's going to take you to prepare. You've known this was coming, and a lot of this material was in Trump's hands. Not that much. Or in counsel's hands for a significant period of time before the grand jury was convened. You keep talking about 12 million pages and his right to a fair trial. He has a right to a fair trial, but what is fair? What is a fair amount of time to prepare? And the 12 million pages here is not actually truly indicative of how much time he needs to prepare. Lauro's fighting with her. She keeps telling him, you're going to be given reasonable time, but not 2 years. Says, I'm pleading, Your Honor, this is a question of one man, one U.S. citizen gets a fair trial or not, and I'm telling you, it's a gargantuan task. I understand we have modern search tools, but none of this takes into the consideration the work the defense has to do to prepare its witnesses or materials. We have to ensure the system works for every American, Your Honor. Trump should not be treated any differently. We cannot be ready under the circumstances of this case until we have a reasonable amount of time under the system of justice. Judge says, Mr. Lauro, I have no doubt that you're capable and that you want to provide Trump with capable representation. but you're not going to get this length of time. And he brings up novelty, and she says, what novelty? Says it's not that novel. It's just a conspiracy charge. A former president being charged is historic, but the alleged conduct, they're not that complex. So why is this case complex legally? I don't know. Good question, Judge. Maybe 11.5 million documents, 12.8 million documents. Maybe that's one reason. Lauro says, are the other cases, do they involve 11.5 million pages? And that's just a start, right? That's just a symbol of the gargantuan amount of discovery. Lauro says, we also have subpoenas. There will be a selective prosecution motion filed, given that the prosecutor's boss is running a presidential campaign. That makes the case novel. We've got some conflict of interest problems. Says, we're going to be busy with very complex legal issues. This is one of the most unique cases from a legal perspective ever brought in the United States. Now, Molly comes back up. Molly says, I think there's a reason Mr. Lauro avoided answering your exact question about when trial should start. He doesn't want to admit. She's the highlighter label gal. He doesn't want to admit that search tools in modern criminal trials mean it's possible to be ready much sooner. She says Trump posted many videos and messages online addressing this probe, showing he knew it was coming. So he should have been preparing before we even indicted him. She said the indictment was sealed. Mr. Lauro called the indictment a regurgitation of the January 6th committee report. So she's now saying that our committee or our prosecution is very similar to the committee report, and Lauro criticized that. And also says Trump has 4 lawyers and also 2 lawyers who attended the arraignment. Trump's lawyers went on air. He went on podcast. He described a number of motions. He said he read Mike Pence's book twice, and he knew what witnesses to call. And so the best way to find out if the defense can meet the standards for trial prep is to set a schedule and see if they can meet it. So just set it, and they'll figure it out, Judge. We're ready. Who cares if they're ready or not? Says selective prosecution motions are not novel in D.C. You know this, Judge. So these are 2 people who just are probably, they're playing patty cake. I'm sure Your Honor knows this. Fraud, conspiracy, not new, not complex. The thing that we need to do is set a trial date. Trump, formerly the senior most official in our federal government, is accused of historic crimes, attempting to overturn the election, disenfranchise millions of people. There's a strong need of public interest to hear this in open court and proceed to a fair trial. Yeah, and they let this guy out on release. She notes that Trump continues to disparage the proceedings, as he should, potentially intimidates witnesses, which is, I don't agree with that at all. And she's saying he potentially mucks up the jury pool as a result in D.C. So as long as he keeps talking about this, it's going to wreck what we're doing here. As more and more people realize how illegitimate it is, I agree with her. The small amount of classified materials in this case doesn't matter. We're going to be able to burn through that. We're going through the classified document steps, and we'll deal with it. Now, Todd Blanche is up for Donald Trump. He updates the judge on security clearances, and Lauro's back up. He says, we're filing more motions to dismiss and other things. Judge takes a brief recess and comes back. She says, all right, look, I understand all too well the need for counsel to have enough time to investigate and prepare for trial. That need is even more compelling in cases like this, where the defendant faces serious charges and penalties. I take seriously the request that he be treated like any other defendant, and I tend to do so. But I also want to point out that most defendants, she says, look, most defendants do not receive this organized summary of discovery. That's what she's hanging this entire case on. Her stinking highlighters. Nonetheless, January 2nd doesn't give enough time, but 2026 is way too far. These offenses occurred at the end of 2020, beginning of 2021. To try it 5 years later poses real danger to the witnesses. Well, hey, judge, you do know that the government chose to bring it today. They're the ones who waited all this time. So why are you penalizing Trump? Chutkan says she says it's in the interest of justice to speed this up, but we can't do it while stripping Trump of his rights. The grand jury in this case convened in September, meaning Trump has known about the government's investigation for a year. So I guess he should have been investigating crimes he didn't know were coming and crimes he didn't know what they were. I've seen many cases delayed because of a lack of representation, but that's not the case here. And so she says, I'm deciding, given all of the things that I've seen here today, including these tremendous sticky notes, Molly, you did a fabulous job. Trial, March 4th, 2024. She said, I've consulted with some competing cases, and that means this trial is going to start 3 years after January 6th. Lauro stands up. He says, okay, Your Honor. Yeah, that's fine. I mean, we'll be here ready for your trial. But this date will deny Trump effective assistance of counsel. So we'll be here for your trial, but I'm just letting you know. We're not going to be able to do our job, and our client is not going to have effective assistance of counsel. You're violating his Sixth Amendment rights, just making that on record. He says, I note your record. What does she care, right? The Court of Appeals in D.C., what are they going to do? A pretrial schedule will be made. I'm going to issue a minute order. Says, Your Honor, defense says, we want to move this case out of Washington, D.C. Says, I'm not inclined right now to do that. Says, I'm watching carefully what Trump is saying for anything that might affect the jury pool or poison that jury pool. If you file a motion to transfer and you haven't, but you're doing polling on the other, it might affect the same jury pool you're claiming is not fair. So she's saying, look, like Trump's general criticisms, if they impact the DC jury, it might also impact wherever you want to transfer the case to. So be careful about what you put in that motion. Says, you may actually affect their ability to render a fair verdict. Are you intending to do this polling? We're going to wait till we get closer to trial. And boom. Judge says, we're not treating Trump any differently. Trial is scheduled March 4th, 2024. So pretty incredible. The judge just doesn't really care about now 10.5 Washington monuments. She says they're nice and organized. They've got sticky notes and labels. Molly Gaston is doing a great job. Trump's defense doesn't need to really read anything. And trial can be scheduled right in the middle of the primaries, one day before Super Tuesday. You see, he's scheduled for March 4th now. Super Tuesday is March 5th. We've also got his classified documents trial starting in May. So we've got the Georgia trial, whether that gets removed or not, we'll see. What the final trial date is there as well, all in the run-up to the November 5th election of 2024, because these people want their opponents off the field. In this case, it's Donald Trump. So ABC News is saying, there's a lot going on here. Even some lawyers are confused by all these very broad charges that are hard to parse through. Here's what they say.
And Donald Trump did say, basically, fundraising, blaming the Justice Department, that is his default mode with these indictments.
Yeah, I mean, but what we're seeing, if you look at these focus groups, you'll see Republicans say that Joe Biden has been so self-evidently a bad president that there's no way he can win in 2024. And when you ask the Democratic focus groups, they'll say it is so obvious that we cannot have an indicted felon as president. So Donald Trump can't win. And I think part of the problem that we're seeing with these repeated indictments, they're very broad. Even some lawyers, I don't think, can follow all of the different sort of charges and what they exactly mean. They should
There's
have
a
gone
lot.
for the narrow rifle shot approach here, the documents case, maybe the fake electors. And instead, we have something much more broad that I think is psychically making Democrats very happy on the left. But in reality, it's exactly what Chuck said, which is it is helping Donald Trump in this primary. It's why he didn't have to go to the debate. He's getting all the media and attention he needs.
Woo! Yeah, I agree with her. I tend to agree with her. I think that there are a lot of lawyers and a lot of lefties who say 91 charges in 4 different courts, because that's what these people get excited about. Remember the 51 CIA people who signed the letter? They're like, 51 people. And they always sign those stupid, like, global warming letters. We have 265 idiot celebrities who signed a document. They care. You should care too. You know, that stupid stuff. So they're trying that here, and it's just not working because people can see what criminality looks like. They can take a look at, cocaine in the White House and think maybe that one's a little bit more legitimate than Donald Trump having classified documents. If Hillary Clinton can smash cell phones with hammers and delete emails with software called BleachBit, and the FBI will twist themselves into a pretzel to not do anything about that, then how does Trump really stand out from that standard? Right? People are waking up and they're starting to see it. But what they're so upset about over here is that people like you and I, people like Trump, are criticizing the process itself. They can't imagine how you could ever question a government entity. Remember when they said that you needed to do certain things during the pandemic? And if you even challenged it in any way, shape, or form, they said you were a science denier. And how dare you deny whatever 3-letter agency said to do? Same thing's happening here, except now they're just translating it from science over to justice. Now they're saying, this is the Department of Justice. This is Merrick Garland. They speak through their filings. They're legitimate people. And when they release a mugshot, they expect us all to think like they do, like this is a legitimate thing and not a big laughable joke, but we don't. Here is Donna Brazil, former DNC person, who is saying this is a travesty because we're making a mockery of the whole system.
We're about to see week after week, starting tomorrow, of repeated criminal trials, or setting a date for his criminal trial, or setting a date for all of the civil action that will take place.
Brought by Biden
while in
and
the
the
short term,
Democrats.
Donald Trump is able to appeal to the congregation within the Republican Party, I think most Americans are turned off by someone who's using his criminality or all of these charges as, a way to raise his profile, to raise money. This is not funny. When you go after the United States, the peaceful transfer of power, when you take documents and don't return them, these are serious charges that he is facing. And at some point, someone in his inner circle, I don't know who, will be able to look in the eye and say, sir, with all due respect, you're going to be in court for the next 6 months, and you're going to miss the NFL season as well.
Oh, my gosh. So these people are talking about how inappropriate it is for Trump to be politicizing this process, for making a mockery, exploiting this for his own gain. Do they realize that it's their team that is prosecuting him? He's politicizing a process that's already been politicized? Is that the point? So they prosecute him and they can go after their political enemies in this country, and Trump cannot respond. If he does, he's politicizing it. See how that works? So it's a very interesting little tactic, now something that they use very regularly. We'll see how it works out for him. Now, this is Alina Habba, who is on to explain to us how they're preparing for this, which is not much because they don't really need to prepare for the truth.
Let me ask you this, the logistics, you saw the timeline there. That's in the middle of running for president, caucuses, primaries. How do you logistically handle, prepping a client for all of those different trials and running for president of the United States?
Yeah, if it was a normal person, honestly, Shannon, I could understand the concern. President Trump is not your average person. He's incredibly intelligent and he knows the ropes. He also knows the facts because he lived them. These are not complicated facts. Look at Fannie. It was a phone call that's been around forever that he refers to as the perfect phone call. What is he going to have to be prepped for? The truth? You don't have to prep much when you've done nothing wrong. So that I'm not concerned with. These trial dates also are going to move. It's unrealistic, it's theatrics, and no judge is going to say that you can be on 2 trials at once in 2 different states, because a lot of these overlap. They look at the start date of the trial, but these are 4 to 6 week trials at the least. So there's no way they're not going to overlap. I mean, they're going to have to go into October, November of next year, again, by design. But in terms of President Trump, the candidate, I have zero concerns.
Okay.
Look at his poll numbers, and he didn't even go to the debate.
Yeah.
Look at Fannie. She is absolutely right about that. Big Fannie Willis out in Georgia saying we don't need any trial prep because there's nothing really to defend. It is all truth and honesty ahead. And, you know, there's some truth to this. I mean, I really don't know. In some of these jurisdictions, in some of these forums, I don't know that there's anything that Trump can do. And I don't know that I agree with her that these trial dates will move. I mean, I think that they'll move, but I think that they have a end game of having the trials occur before the election. They want a conviction before the election, and they're going to do whatever they can do to get that done. So we'll see. This is what they are up to. Insane trial date for Donald Trump, March 4th, 2024. Of course, we're going to continue to cover it. Things are going to go fast, my friends. We're going to see a slurry of motions from Trump in response to this, because this, of course, is insane. And of course, we'll continue to cover. Thank you for subscribing and joining along as we do, and we'll look forward to seeing you on the next one. All right, my friends, let's motor on through and see what's going on with Mark Meadows. Donald Trump's former chief of staff, Mark Meadows, had a very important hearing in federal court, and there are questions about what happened there. We have an interesting thing in these prosecutions coming out of Georgia. We know that there are 19 total co-defendants in the case. It's a RICO case involving conspiracy. But what happens when we start to sever cases? What happens when we have some people have a trial very quickly under speedy trial rules? Other people have trials late. What happens if we have some trials happening in the federal court because there are federal officials that need to be prosecuted in federal court versus other officials who are not federal officials that stay in state court? Going to be complex. But today we had a hearing on this one. Meadows is trying to remove himself from federal court and to dismiss the case, to segment himself out from all of the other co-defendants. And one interesting thing happens with co-defendants, and prosecutors try to exploit this, is to get people to point their fingers at each other, offer them plea deals, get their statements on the record so that they can use them against other people as they continue to pursue charges. So what happened in Mark Meadows' case? Well, he took the stand, apparently. Pretty amazing. We saw that there was a series of questions that came back, and he was supposed to be due back in court, likely in for a long afternoon, says Anna Bauer. Might go back into another day, right? So some serious testimony was happening in court, but no phones were allowed in court. So we're not able to see a live tweet thread. Instead, what we've got is some reporting after the hearing took place. And apparently, we see that Meadows testifies today, and some people are saying he pointed the finger at Trump. Now, I'm always skeptical about these framings, but we'll see. And this would not be unusual. And the question is, does that matter? So what? If everybody points their fingers at Trump saying, he told me to do the thing. So what if he's allowed to do the thing? If you're allowed to investigate elections, if you're the executive branch and part of your job is to execute federal elections, you run the DOJ and these things, you're allowed to ask questions. So if they point the fingers back, so what? He is the root source of the power because he was the president. The article tells us that a battle over whether to move the case from state level to federal level is underway, and Mark Meadows testified today, which caught people by surprise, stated emphatically that he believed that his actions detailed in the indictment fell within his scope as duties as chief of staff. This is what he's saying gives two things. One, immunity to justify a dismissal, and two, removal to pull this up from state court. But he also appeared, according to the New York Times, unsure of himself at times, saying often that he could not recall details of the events in late 2020, early 2021. My wife will tell you sometimes I forget to take out the trash. Oh, I love that. Yeah, I can be very forgetful too. Yeah, it happens, Mark. I understand. He told Judge Steve C. And by the way, don't think that that is unusual, okay? Hillary forgot everything. She forgot everything. So did Mark Elias and Michael Sussman. Remember those guys? They forgot everything when they were framing Trump. At another point during the day-long hearing, Meadows asked whether he was properly complying with the judge's instructions. Is this going the way you want it, Judge? I'm in enough trouble as it is. The effort to shift the case to federal court is the first major fight. Meadows testified in this court proceeding. Meadows testified that Mr. Trump directed him to set up the now famous phone call on January 2nd between Trump and Brad Raffensperger. This is the phone call that the media hyperventilates about because Trump asked Raffensperger to, quote, find 12,000 more Trump votes that would flip the outcome, which is what you talk about when you are in an election. You got to talk about things called votes. You got to talk about the number of those votes so that you can identify the margin between what you lost by, if you're going to have a question about that. Now, find the votes means you can do an audit and discover them, right? Or you can find some error that disqualifies whatever it is, legally. Doesn't say create 12,000 votes, doesn't say fabricate 12,000 votes, nothing. Meadows testified in court. He said, I was asked to reach out. But he did say that Mr. Trump wanted to make the call because he believed fraud occurred, genuinely, and wanted to resolve questions about ballot signature verification process. Meadows said, we all want accurate elections. He also testified that after being subpoenaed by the prosecution, Raffensperger testified. So Brad Raffensperger was there. He said that after being subpoenaed by the prosecution, he said, I had ignored calls from Mark Meadows. I didn't think it was appropriate. So I tried to avoid those calls. He says, I tried to avoid the call with Trump too. He said, outreach to this extent was extraordinary. If the effort to move the case to federal court succeeds, it could benefit the Trump side. It could broaden the jury pool. This is what they're petrified about. Beyond Fulton County into outlying counties where he's got more support rather than a dark blue county. It could also slow down at least some of the proceedings. Chesebro, Sidney Powell have already requested speedy trials. They're probably going to get them as it stands now. Meadows was also cross-examined. Somebody named Anna Cross was there, apparently a veteran prosecutor, worked there in Atlanta. She continually pressed him on what kind of federal policy or interest he was advancing. Meadows said essentially his job has been to simply help the president. That's all I do. I help the president. When Trump had concerns about elections, he said, I looked into them because they could result in policy changes about election integrity. She says, well, when you visited Cobb County in Georgia where they were auditing ballots, what were you doing there? Says, in his mind, there were still allegations worthy of investigation. Meadows has been charged with racketeering and the other crimes. And so that's essentially what happened. Now, I also saw this article from Politico, and they're telling us, listen to how this works. You know, we talk about how they, in the media, will conjugate headlines, how they'll just change the language to give it certain emotions. So here you see this headline. Mark Meadows takes the stand in a bid to derail Georgia criminal charges. Or, you know, maybe like defend himself or like tell the truth or testify. Mark Meadows testifies in Georgia prosecution. Why is he derailing criminal charges? Don't we have the presumption of innocence in this country? They're not automatic. Same story here. He was in there for 2.5 hours testifying during the morning session, and then it came back. If they argue that it's within the scope, Meadows may be immune from the charges against him because they're currently brought under state law. So we'll see if Mark Meadows floats that or what happens with this, and we'll get updates on that soon. But this is what the people on the left were saying about all of this. And something I noticed about this, we'll listen to a little bit here. We've got two people. This is MSNBC. This is Jen Psaki, right? Where did Jen Psaki come from? Jen Psaki came from the White House, right? And so the White House has their little roadmap, right? You got somebody who gets a job there. They do the shill thing for a year. Then they go get a job at MSNBC. But something else is interesting. We've also got this guy, Neil Katyal, who they call a legal analyst, but he's a former Solicitor General, also worked for the government. He's a regular on this. They call him a MSNBC legal analyst. So we've got one person comes out of the government, lands here. Another person comes out of the government, lands here. And guess what? Another person comes out of the government and lands here. This is Andrew Weissman, former FBI General Counsel. Okay, so this guy lands from the FBI. One person lands from the White House. One person lands from the FBI. One person, this guy, lands from the Department of Justice, Office of the Inspector General. And now they're all going to sit around here and talk about how everything that's happening here is totally legitimate, right? The same people who orchestrated this are all going to sit around and talk about how legitimate this is. This is their old employers. These are their old friends. These are their old institutions. They're all anti-Trump. And once they leave the agency, they just go get a job somewhere else, but their friends still work there. And so this is them just playing the patty cake game.
By popular demand, joining me now is who else but the law firm. Neil Katyal is the former acting U.S. Solicitor General, and Andrew Weissman is the former FBI General Counsel. And I'm so thrilled to have you here on set with me today, Neil. So there's so many different components of this week, and I want to dig into as many as possible. A judge granted Kenneth Chesebro's request for a speedy trial. Sidney Powell filed her own request. There are also reports that John Eastman is asking for the same thing. That means that a number of these co-defendants would be separated from Donald Trump. Mm-hmm. What does that mean for Trump's case?
Okay, so there's two January 6th cases. There's the Georgia one going on that you're talking about now, and then there's the federal one, which Jack Smith has asked for a trial to begin on January 2nd of 2024.
But that's
with
gonna
respect
be
to this request from Ken Chesebro, who is one of the architects of the January 6th coup.
Who's walking around free, all these people.
Said, I want a trial right away on October 23rd. Fani Willis, the prosecutor, says, yeah, game on. The judge says, fine, game on. So what this means is that the first January 6th trial will happen. It will likely be
in Georgia,
and it will likely be just Mr. Chesebro or perhaps with Sidney Powell, who's also asked for a fast trial. But it won't likely involve Donald Trump or the other 16 defendants that are named in the indictment. But that means it's a signal this stuff is starting to happen, and if you're Donald Trump, you've got to be very worried.
Well, I don't know that we're necessarily worried about it, but one concern with some of this stuff is just what we saw previously with Mark Meadows. Okay, Mark Meadows is now saying stuff. So when everybody comes out to testify and when everybody starts to litigate their own cases, you might start to hear some things between all these different co-defendants who are all kind of on their own that might be troubling for other co-defendants. And we're obviously analyzing this case from the Trump frame of reference. And so we're all kind of asking ourselves, what are the consequences for Trump? But we don't know what these other 18 co-defendants, where their heads are at, whether they care at all about Trump, right? I would imagine many of them do, but maybe one of them doesn't. Maybe two of them don't. Maybe, I don't know what Kenneth Chesebro's strategy is, or what Sidney Powell's going to do. Or are some of these people going to defend themselves at the expense of other co-defendants or other Trump in particular, right? Is Fani going to put pressure on somebody to flip somebody or something? And as these other things happen outside of the Trump bubble, we get questions about what those are. We don't know. There could be nothing that pops up, but there are variables that pop up, and we just don't know exactly what it is. And so in court, we like to keep things as contained as possible, as minimal surprises as we can possibly have. And when you have all of these fast moves, fast trial, Sidney going, other guys going, it starts to create some volatility that may lead to some trouble.
So, Andrew, just to pick it up where Neil left it there, why should Donald Trump be worried? What does it mean for his case?
So I think there's the court of public opinion, and there's also the issue of just, the legal court. So just let's focus on the court of public opinion. As you mentioned, Jen, in your intro, I mean, what Donald Trump is trying to do is litigate this in the court of public opinion and just spin facts to say this election was stolen.
Right.
As Neil pointed out, that is very soon going to be in a forum that he cannot control, and he won't even be a defendant in that courtroom. So there will be facts and law that is going to be going on at the end of October in Georgia. And there actually is going to be a hearing tomorrow with respect to Mark Meadows, where again, facts and law will be presented and Donald Trump will not be there to spin his version. So I think just from both from sort of what's going to go on in court, but also his whole play, which is to try the
Yeah, I mean, I think he's kind of making the same point that something volatile could happen, but I don't buy the premise that Trump is able to spin in court at all. He's not been able to do that at all. He gets steamrolled in court. He got steamrolled by Judge Caplan in the E. Jean Carroll case. He just got steamrolled by Judge Chutkan in this case, 2 extra months to review 11 million pages of discovery. So even when he is there, like even when Trump is in court, he's not allowed to twist anything. The government and the DOJ and the judges twist everything against him anyway. So I don't know that I agree with that critique. I think that regardless of Trump's presence, Trump is still going to, I think, win in the court of public opinion either way, unless we do get a defendant who, flips and joins Fannie for whatever reason, and something surprising comes out. But I just don't think there is anything there.
This in a place where he can just make up the facts and the law that he wants.
Like you guys
That is
do?
going to be really hard for him going forward because you have these divergent defendants wanting to get into court sooner.
So, Neil, Andrew referenced this Mark Meadows trial. There's a lot happening tomorrow, actually. So let's.
All right, so we covered all the Mark Meadows stuff, and we know that there will be a ruling on that at some point. So we'll see what the judge says about the removal. I'm sure we'll get a written opinion on it when it drops. We'll continue to cover it, my friends. Thank you for subscribing and liking this video wherever you're watching, and we'll see you on the next one. All right. And so with all of that being said, let's see where it leads. We've been following the bouncing ball here for a little while. We know that there was this theory that under the insurrection clause of the 14th Amendment, that some people were arguing, college professors and others, saying that Trump should not even be allowed to be placed on the ballot, saying he was already disqualified because January 6th happened, and there's this self-executing made-up feature of the Constitution that says that just like somebody who's under age 35 or somebody who's not a natural-born citizen, they can't ever even apply to be put on the ballot. Those are qualifying features. They're also saying that a disqualifying event may prevent you from qualifying to be on the ballot. In this case, insurrection is the disqualifying event. And this is a lawsuit that has been filed by a Florida man now to keep Trump off the ballot. The theory emerged. It was discussed and published by MSNBC, Judge Luddig and Lawrence Tribe. We saw the GOP pick this up and ran with it with Asa Hutchinson at the debate, saying Trump may not even be qualified to be on the ballots. And now the actual lawsuit has been submitted. You see here, it is 7 pages filed out of the Southern District of Florida. The case is Lawrence Caplan versus Donald Trump. This guy's a lawyer, evidently, and let's see what he says. Petitioner Lawrence comes before this court seeking declaratory relief, asking the court to do something, just to make a declaration on the specific issue of whether candidate Donald John Trump is indeed constitutionally prohibited from seeking a second term as president. Encompassed within this request for a declaration is a further determination as to whether Trump is indeed even eligible to participate in the primary in the spring of 2024. In bringing this request for a declaration, They say that me, Lawrence, has carefully studied the specific provisions of the Constitution which govern whether an individual who participates in an overt rebellion or an insurrection against the government is effectively disqualified from service in the federal government as president. Done some studying here. For purposes of standing, they say this man asserts that he has actively participated in the last 12 presidential elections dating back to 1976, when he cast his first vote at the age of 18. It should be noted that in the course of these 12 presidential elections, Lawrence has voted for both Democrat and Republican tickets and was a registered independent for many years. He's a legal resident of Florida, been a member of the Florida Bar, he's a lawyer, and a bar of California, Oregon, currently a member of the Tax Court, Southern District of Florida, Court of Appeals, and the U.S. Supreme Court. Never been sanctioned or suspended. The facts of this case, writes Lawrence, are undeniably simple. Donald Trump served as the 45th president of the United States, having won the election and being inaugurated. 4 years, but Trump chose not to appear at the inauguration of Biden, having left his estate for South Florida. What, is he upset about that or what? On January 6th, after giving a speech to a throng on the ellipse near the Capitol, Trump exhorted the throng to march on the Capitol and told them that he would be right there with them. After he finished with the speech, Trump returned to the White House and watched the events unfold, as he says. As we're all well aware, the throng marched on the Capitol, forced their way to the Capitol building, ransacked the Rotunda area, even made their way into several offices of representatives and senators. Yeah, this was the same event that Ray Epps was at, screaming, "Let's go into the Capitol." He was there, never got charged. Nancy Pelosi was there, filming the whole thing. We know that from the Proud Boys trial, the defense there alleged that there were at least 50 undercover informants, not from the FBI, but from Homeland Security investigations called HSI. You remember that event. As the confirmation of the results were being undertaken in the House, alarms went off. Members scurried. Of note, Vice President Mike Pence missed being reached by some of them by a matter of seconds, he says. Eventually, several high-ranking members were shuttled to a safe area. Of note, President Trump had sent out a tweet that day, says, "We'll be wild." And he remarked that the insurrectionists were special and that we love you. Did he say that? Did he say we love insurrectionists in his tweets? He later remarked that Vice President Pence simply did his job, and so on. Now, what we're seeing here is sort of looking like a rant a little bit. Since the events of January 6, hundreds of insurrectionists have been charged and tried, which is a very tiny number relative to other jurisdictions. Recently, Special Counsel Jack Smith has been appointed. Trump was arraigned on these charges. And so basically, I think he's making the argument that he's been arraigned. He now awaits trial sometime in 2024. It should be noted that Trump has also been formally indicted on charges of secret documents, classified documents, which is a federal offense. And we have another typo, man, another one, and has also been indicted in Manhattan. However, none of these crimes have the effect of preventing Trump from seeking re-election in November. So here's where he gives us the law now. All right, this is a lawyer. He says the 14th Amendment to the Constitution, ratified 1868, shadow of the Civil War. Section 314 automatically, you see this, automatically excludes from future office any person who has taken an oath but acts to rebel against the charter, either via overt insurrection or giving aid or comfort. He says, in carefully analyzing the language embedded in the Constitution, numerous legal scholars have wrangled with the preeminent issue of whether an actual conviction is necessary to trigger the prohibition of running. It's the disqualification clause. Has been determined, they say, to operate completely independently of any criminal proceedings, also independent of impeachment and Congress. Wow, it's a magical clause. It's a miracle. It operates on its own. And it's weird, you know, like we just found it. The country's been around for a while. We just discovered this, though. And what's so awesome about it is it's the perfect thing we need to take out our political enemies. Isn't that fun? Now, former federal judge Michael Luddig of the Court of Appeals and noted legal scholar Lauren Tribe, okay, I'm pretty sure his name's Lawrence. Yeah, it's Lawrence. Yeah, it's definitely Lawrence. Yeah, it's definitely Lawrence. It's not Lauren. But have come to the inescapable conclusion that the disqualification clause, okay, so first of all, Judge Luddig is an idiot, in my humble opinion. And, Lawrence Tribe is, let's say he's partisan and overtly biased. Yes. Here, they've both come to the inescapable conclusion that the disqualification clause was designed to operate directly and immediately upon certain individuals named Trump. I wonder if did the founders write Trump in there too? Who betray their oaths to the Constitution, whether by taking up arms or waging war or by attempting to overturn the results of an election through a bloodless coup. I don't remember any of that language in the Constitution. I don't remember it. Where'd these guys find it? It's incredible. They read through, it's a miracle. They say Trump's efforts, both in Washington and Georgia and other states, as well as the assault on the Capitol, put Trump at the center of the disqualification clause. And as a result of which, make him ineligible to ever serve in federal office again. Oh man, he probably was really enjoying writing that. Never again. Now, given the facts that seem to be crystal clear, right? So anytime a lawyer says crystal clear, it's almost never crystal clear, just as a general rule. It seems to be crystal clear that Trump was involved to some extent in the insurrection that took place. The sole remaining question is whether American jurists who swear an oath to uphold the Constitution upon their entry to the bench will choose to follow the letter of the Constitution in this case. Of note is that during his one term in office, Trump appointed 3 justices, Gorsuch, Kavanaugh, and Amy Coney Barrett. Shout out to some good judges, who are viewed as conservative jurists who err on the side of a strict construction of the Constitution. They overturned Roe versus Wade. And so therefore, we must look at the strict interpretation because they use the strict interpretation. Interestingly, Section 3 of the 14th Amendment, which provides for disqualification, has remained on the books for 150 years. While one can argue it hasn't been tested, the fact that we have it is because we haven't faced an insurrection before. And Trump has since made statements to the effect that should he be elected, he would advocate for the total elimination of the Constitution. Trump said that? Trump said that if he's elected, he's going to have total elimination of the U.S. Constitution. Trump's going to create a new charter more in line with his personal values. Oh, I had no idea. Wow. Interesting. I didn't realize that was a thing. Is that part of his new campaign? Incredible. So the 14th Amendment was promulgated and ratified in the context of the Civil War. Any number of top scholars, including Judge Luddig, who's not that intelligent at all, can hardly talk, and Lawrence Tribe, there we go, got the name right on that one. They conclude that Section 3 requires absolutely no legislation at all, no criminal conviction, no judicial action at all. It's just automatic. Trump is disqualified. So, look, I know that this lawsuit's kind of goofy, and we can kind of laugh and joke at this, but this is just the first draft, my friends. There will be a lot more like this, and the next ones aren't going to be so jokey, and they're not going to have typos, and they're going to have citations, all right? This is just the rough draft. In legal terms, Section 3, they say, is completely self-executing. It happens on its own. No presumption of innocence, no due process at all. They conclude that disqualification subject to Section 3, another typo, does not constitute a punishment or a deprivation of liberty. We're not depriving you of anything. You just don't qualify. Just like if you're 26 and you want to run for president, we're not depriving you of anything. You just don't meet the qualification. You don't have an absolute right to serve in office. And so all we need Also, as a second point on this, even if this lawsuit is goofy, almost doesn't matter. You just need a Judge Chutkan to stamp it, all right? You just need a judge to take a look and say, I like your argument. There are good highlighters here. Nice notepad. And they just stamp it. That's it. Then one Secretary of State decides, boom, got what I need. Then it's going to fall like dominoes. They're all going to start doing it. Lastly, the scholars conclude, he says, that Section 3 is expansive. It's all-encompassing. And it really defines insurrection or rebellion against the constitutional order. Very broad. Says, taken along these same lines, had it been conclusively proven that Obama has not been born in Hawaii, the Constitution would have barred him from seeking presidency because he's not natural born. And petitioner is convinced that there would have been no wiggle room. So he's saying, I would have found this same principle against Obama, by the way. That's how you can know that I'm credible. Furthermore, had President Trump merely been thought by many individuals to have engaged in an insurrection, that would have not sufficed. Merely been thought by many individuals, that would have not sufficed. However, the fact that he's been formally indicted, okay, so that's the line. So that's weird. So there is some process. The fact that he's been formally indicted for various felonies, including insurrection, mandates that this be triggered. Okay, so it's not actually automatic. So something triggers it. In this case, it's the filing of the felonies. So that, I mean, somebody's got to do something. The bottom line here is that Trump both engaged in insurrection and gave aid and comfort to others. Assuming that the public record is accurate, with no evidence to the contrary, this lawyer, who's licensed in multiple states and the Supreme Court, says Trump is no longer eligible to seek the office of the presidency. This court has the innate power to rule that the Constitution, the tenets, require to find that Trump and his actions with January 6 aiding and the fact that he's been indicted effectively disqualified him from becoming president. Effectively bars him from seeking the GOP nomination in Florida. We're asking for a declaratory judgment so that it's abundantly clear what happens. We're asking that you follow the language of the Constitution, and this decision should be relatively easy. So, Your Honor, please enter a declaratory judgment saying that Donald Trump is barred from seeking the office of the presidency and the primary, signed by Lawrence Caplan, Florida man, filed in court, federal court, Southern District of Florida, where certainly he has standing and where Trump resides. And we'll see where this case goes. But yet another attempt to keep Trump off the ballot because, well, they don't want him on there. You see, here's the summons. Summons, personal service on a natural person. Donald Trump is going to get served here. A lawsuit has been filed against you. You've got 20 days to respond. Sued by Lawrence Caplan. And we know that the lawfare game will continue. This, my friends, I think is a real serious threat. I think that there will be a lot more of these filed. And all they need is one. They just need one judge somewhere to grant it. And then they're going to say it's precedent. And the rest of the dominoes, they'll say must fall. Because that's what the Democrats want to do, is keep him off the ballot. Because if they allow the people to vote on that, on him, somehow that's undermining democracy by allowing us to participate. So we'll continue to cover it. I think this is the first attempt of many. Thank you for subscribing, as we do. All right, let's carry on, my friends. We've got one final segment on the day. The White House colluded with Jack Smith, the Biden White House, meeting with the Special Counsel's office, not appropriate in any way, shape, or form because Biden is prosecuting Trump, which is what the Special Counsel is supposed to be inquiring about. So they should not be connecting in any way, shape, or form, but they did. We know these two people, according to visitor logs, Caroline Saba and this guy, Jay Bratt, not supposed to be hanging out. She's the White House Deputy Chief of Staff for the counsel's office. He works for Jack Smith. These two people met, and maybe they fell in love. We don't know. But here's the story. The visitors logs tell us that they met before the Trump indictment ever came down. Jay Bratt, the guy we just looked at, who joined Jack Smith's team in November 2022, shortly after it was formed, after they started the investigation, took a meeting with the White House, March 31st, 2023, with Caroline Saba, Deputy Chief of Staff for the White House Counsel's Office. This all came out thanks to visitor logs. We know that they were joined at 10 a.m. in the morning by Danielle Ray, an FBI agent from the Washington field office. 9 weeks later, after these little lovebirds all met to plan their plot against Trump, Trump was indicted by Jack Smith on June 8th, 2023. Bratt, the prosecutor, 63 years old, also met with Saba at the White House back in November 2021. So they're meeting repeatedly about this. And there's supposed to be a big separation here. Joe Biden said that he didn't get involved at all with what Jack Smith was doing because Merrick Garland was handling it and he doesn't talk to them. We all know that that myth has been shattered because of what the DOJ did with Hunter Biden. They say here, Trump was mired in negotiations. They were meeting. The prosecutors going after Trump were meeting with the White House to basically, I would imagine, advise them on how to tell Trump what to do with the National Archives, and they indicted him. Saba, who's not an attorney, left the White House in May to attend law school. So she's not around anymore. After whatever happened, she decides to abandon ship. Bratt had a third meeting in the White House in September 2021, and he also met with Catherine Riley, another advisor to the White House Chief of Staff's office. Okay, that other woman, Saba, was at the White House counsel's office. This is an advisor to the White House Chief of Staff. That is Joe Biden directly. The logs offer no information about what was discussed at the meeting. Oh, of course not. Critics and legal experts question why Bratt was taking the meeting with the White House counsel at all, because he's investigating his Republican opponent. Rudy raged about this, says there's no legitimate reason for this at all. Counsel for the special counsel's office, Peter Carr, said Bratt was there for a case-related interview. No further comment. White House, no further comment. FBI declined to comment. A person with knowledge said that this was an interview of a career official who is also working at the White House during the Trump administration. So it's a total scam, okay? These people have been colluding to get this done for years, and they dropped it right at the appropriate time, right in the middle of a campaign season, because they are trying to win, trying to scam all of America into buying their story. And there are a lot of scammers out there, including robocallers. That's our ad interview. So now we're going to insert the Aura read. All right. But that's our live stream privilege, so we'll carry on. Robocallers, don't you hate them? All right. But the Democrats continue because we know that the DOJ didn't stop just with the Jack Smith investigation, but they also intervened on behalf of David Weiss. And we remember David Weiss as the prosecutor who corrupted the Hunter Biden plea deal. Well, the Washington Federalist, they came out with new emails and a new report, an exclusive, saying that David Weiss, the Hunter Biden prosecutor, colluded literally with the DOJ to thwart congressional inquiries. After the whistleblowers came out and started speaking about what they saw within the DOJ, all of the corruption, they blew the whistle. Congress demanded answers from David Weiss, and once again, Merrick Garland and the White House intervened. They coordinated the special counsel's investigation. They're stepping in to interfere with the Hunter Biden investigation. Emails reveal the following. Margot Cleveland reporting says emails obtained by the Heritage Foundation through a FOIA request established conclusively that on multiple occasions the DOJ intervened on behalf of David Weiss. The revelation raises more questions about a prior letter. David Weiss, as we recall, sent a letter back to Jim Jordan and he said, I've got total authority. I can do whatever I want, and I'm not going to answer your questions, but I can file charges wherever I need to file charges. This was the letter that he sent. Now there's questions. Did he actually type this letter up, or did somebody else draft this puppy for him? He said in the letter that he had ultimate authority over the charging decisions, but we know that's not true because now he's got special counsel status. And the whistleblowers told us that he was the person who asked for information or permission to bring charges in DC and California, but was denied. So why would he need special counsel status to get permission for something that he already had authority to do? Questions are, did the DOJ's Office of Legislative Affairs respond to them? Weiss posed that question to one of his lead attorneys. The following month, Grassley and Johnson, who are two senators who've been on top of the Hunter Biden investigation for a long time, they sent another letter to David Weiss, as well as Attorney General Merrick Garland. The Office of Legal Counsel again intervened, telling Weiss's office in an email that was reviewed by the Federalist that the Office of Legal Counsel would take the lead on drafting a response. Why wouldn't David Weiss take the lead? The never-before-seen emails established that the DOJ and the U.S. Attorney collaborated in responding to congressional inquiries and were among the first batch of documents provided to the Heritage Foundation that they got. They sued. The court ordered the DOJ to produce documents, all records collected from Weiss and Assistant U.S. Attorney Leslie Wolf. Woo! That's going to be good. I hope they drop some more documents. Mike Howell, the director of the Heritage Foundation's Oversight Project, initiated the FOIA request. They filed a lawsuit, and they're running communications from Weiss through the Justice Department. David Weiss had no control over anything. The emails also call into question the veracity of exchanges between Weiss and Jordan. He's not even responding to congressional letters. Even though the House committee addressed the letter to Garland, Weiss responded to the letter. Two more letters would soon follow, and we've read through almost every one of these here. Weiss responded in the June 30th letter. He says, I'm not at liberty to discuss these things. He sidestepped the questions. So, very interesting update. So, apparently, the Office of Legal Counsel is interfering and usurping the chain of communication between Congress and David Weiss. And so the DOJ is about as corrupt as you could possibly imagine. Not only are they being orchestrated by the White House to prosecute their political opponents in Donald Trump, but they're also using the DOJ to protect their favorite defendants, which of course, as we know, is Hunter Biden and many other Democrats. But what are the Republicans going to do about it, if anything? McCarthy apparently is considering a plot to impeach Biden. When the Democrats impeach Trump, it's to preserve America. But when the Democrats are getting impeached, McCarthy is plotting. See how that works? So he's talking about it, and there's this breakdown in the Republican Party whether we should impeach now or impeach later. And Kev is getting it from both ends, and here's what they tell us. He says that McCarthy and top Republicans have begun to strategize about how to move forward with an impeachment inquiry this fall. The latest sign, the GOP is laying the groundwork for serious considerations. In recent weeks, McCarthy has privately told Republicans he plans to pursue an impeachment inquiry into Biden, hopes the process to start by the end of September, according to multiple sources. While McCarthy has already publicly threatened to launch an inquiry, if allegations from whistleblowers hold up, sources say that McCarthy has sent even stronger signals about his intentions behind closed doors. Leadership recognizes the entire Republican conference is not yet sold on the idea. Still lingering questions. Republicans currently do not have the 218 votes yet needed to open the inquiry. They don't want to skip the vote in order to do it. Matt Gaetz says, I don't think that we need a vote. I don't think we have to do it in order to open up an inquiry. But we're talking about timelines, and they're saying government funding also expires at the end of September. Oh, we're out of money again? Officially, moving ahead with an impeachment inquiry could keep angry conservatives off McCarthy's back. We'll see what he does about it. We do know that the votes seem like they're just not quite there. Marjorie Taylor Greene explains.
Well, you know, I introduced articles of impeachment on Joe Biden's first day in office. So it's not me. I'm not the holdup. It takes 218 Republicans in Congress to pass any bill. To pass anything in Congress, you have to have 218 votes. We only have 222 Republicans in Congress. And unfortunately, we don't have enough strong Republicans. But I'm hoping to see them get there on this because Joe Biden is now, it is proven that he lied to the American people. He lied to the American people about his business deals with his son. We had Devin Archer, Hunter Biden's former business partner, come in and say Joe Biden was on the phone with them over 20 times, met with business partners in person. We also have an FD 1023 form that came from the FBI's top informant. And the FBI paid this guy $200,000 for this information. And the information that the informant brought said that Joe Biden took a $5 million bribe while he was vice president of the United States. He took that bribe in order to get the prosecutor from Ukraine, Viktor Shokin, fired. And guess what? Joe Biden is on video himself admitting that he was going to hold $1 billion in U.S. aid, all in order to get that prosecutor fired. And then he bragged about it, and he did get fired. So these are the crimes the American people deserve to know about, because no president, no politician in Washington should be able to enrich themselves on the American taxpayers' backs, abusing their power and making policy decisions and getting paid for it. And that's what the Biden family did. That's what Joe Biden has done while he is persecuting President Trump. And that's what we have to do. There's no way that Republicans can go forward in Washington without passing an impeachment inquiry.
We'll see if they do it. I think that she's right that there is mountains and mountains of evidence. Byron Donald says that they are now obstructing justice. The same people who are charging Trump with obstruction are doing a lot of obstruction themselves.
Look, it's not just about the fact that Joe Biden is corrupt and Crooked Joe is corrupt.
Yeah, that's true.
But he's also inept. He's been a disastrous president. Pick any issue you want. He's been a failure, except for one thing, and that is moving the agenda of the radical left, Bernie Sanders agenda. That's the only thing he's been good at. Everything else has been a disaster for our country. Couple that with the fact that you do have Merrick Garland and the Department of Justice obstructing justice. That is exactly what they've been doing by shielding Hunter Biden and Joe Biden from any investigations whatsoever, and at the same time turning all the power and the resources of the federal government pointed at Donald Trump and pointed at other people in the Trump orbit. I mean, you can go back as far as Roger Stone, Paul Manafort, General Michael Flynn. This has been a consistent effort from the radicals in our government. And this is about the American people doing their job, changing this government so we can get a country of, by, and for the people back that actually follows the rule of law.
All right, Byron Donald.
Look, it's not just.
And others in the House still doing what they can to expose what they know, rally support, hopefully convince other Republicans in Congress that something needs to be done. It's about time. It's kind of amazing that there's not even Democrats now who are screaming from the rooftops saying enough of this corruption. But we know that it's now a political blood sport. And so even though the White House is colluding on both ends to protect themselves against prosecution and to persecute their political opponents, they'll just keep marching on. We'll see if the Republicans do anything about it. As we carry on, my friends, thank you for liking and subscribing wherever it is you're watching this, and we'll see you on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. White House collusion, Donald Trump removal from the ballot, Mark Meadows maybe pointing the finger at Trump or maybe not. We've also got an insane trial date, March 4th, 2024, and there's going to be a very increased pace, I imagine, very soon. If we're going to be having trial early next year, things are going to accelerate very quickly. But now, my friends, it is time to hear from you, of course, from our friends over at watchingthewatchers.locals.com, our friends as YouTube members, our friends on Rumble. We'll say hello to Twitter, and then we'll jump into our members-only after party after the show. And so First one kicking us off today is 2012 Jameson in the house. Good to see you, Jameson. Hope you had a good weekend, my friend. Says the following, says, will you read a petition I am drafting? Yeah, I'll take a look at it, Jameson. No problem. Send an email. Don't know that we'll read it here on the show, but I'll take a look at it offline, certainly. Good to see you. Ned Frankley, what's up, Ned? Bringing in 5 new members, our friends Maynard, Mama Pillow, Ray Star, Deanna Gray, and Gyro P, all in the house. Thank you, Ned Frankley, who's been a member. Appreciate you, Ned. Thanks for bringing in 5 new members. We've got this one from John Allen in the house. Says, hi, Rob. Just wanted to throw this out there. Continued prayers for Bonnie and daughter Jen. And thank you, John. Yes, again, we're praying for Bonnie and daughter Jen. And we've got a little Watching the Watchers community token of our love and prayer going their way. Thank you, John. We got pickle jars for Hillary saying, Judge Chutkan doesn't seem too bright. Well, she does like highlighters, so she likes bright markers. That's true. Deanne David as a supporter. Welcome, Deanne David. So, hey, if you're a YouTube member, join, grab the Telegram link and join us on Telegram for our members only after party. And Deanne David, we'll see you tomorrow morning as well for our members only morning streams. Fred's here. What's up, Fred? Says, if this were a Democrat president, the U.S. would be a wasteland already. Charred wasteland already. Imagine BLM, Antifa, and the rest. Our country would be an armed civil war. Oh, like if Trump were prosecuting Hillary this way, or like if Trump had prosecuted Joe Biden this way, yeah, they would freak out, and it would be a big problem for them. Good to see you, Fred. Tony Hay Munkits is here. Says, what if Trump just invaded the courts and went on the run? Could we still vote for him? I'm not suggesting he do that. I just think it would be funny. Yeah, I think that Trump could probably flee and still run. You can run as a convicted felon. Can you run as a warrant fugitive? I think so. Why not? We vote him in, and then he can do whatever he wants on the aftermath. Andrew Richardson is in the house. Good to see you. Andrew Richardson, welcome as a supporter on our amazing YouTube member community. Hey, Derail's here. Says, she said most of the documents went through Trump's hands. Trump is said to have small hands, but he holds a stack of paper a mile high? Something doesn't add up here. Yeah, that's a good point, Derail. How can Donald Trump read an entire Washington monument full of discovery if his hands are so small? I mean, they must be gigantic because the Washington Monument. We got Music Micro Gaming Mix in the house. It's good to see you. Thank you for the dono. We got The Good Doctor says millions of dollars of fake accounts are transferred to fake front companies, even to children of the Biden family. That's nothing, right? Nothing to them. Shai says, one a felon just because they're indicted? Make it make sense. I swear this becomes a bigger mess on the Constitution every day. Yeah, they're saying he needs to be removed just because of the indictment, not because he's been convicted. Just the fact that somebody thought that they could indict him is enough to cross that threshold. Pretty insane. We got Music Micro Gaming Mix is in the house. Thanks again. We got this one. I think this one's from John. It says, Rob, if we have seen with quote, the fixer, these co-defendants will flip and say whatever they're told to say to stay out of prison. Whatever they are told to say to stay out of prison. Yeah, you got to get worried about that, concerned about that if they just flip their testimony. Nobody wants to go to prison, and these people are mad with conviction fever. So we got Rocky Water throwing in for the tip jar. Says naughty word. Sorry about that. Sometimes it happens, Rocky. I get it. Music Micro Gaming Mix, another one. The doctor says, this so-called lawyer from Florida, why can't he be disbarred? The only remedy for a president to be removed and prevented from office is impeachment. He's promoting a frivolous case. Can I file a bar complaint? As a non-lawyer, I understand unless you are convicted, the conversation shouldn't even start. Why is this different in any way from what they claim Sidney Powell did? So a lot there, NY. I would encourage you, well, we can talk about it a little bit more on the after party, but certainly you can. I don't know if it's going to go anywhere, but you can certainly file one. We got Jack Max here. What's up, Jack? Says, isn't the idea that J6 was an insurrection pretty subjective? Yes. It hasn't been charged yet. In August 2021, the FBI found scant evidence the U.S. Capitol attack was coordinated. Per Reuters, correct me if I'm wrong, no indictments for insurrection. No, not a one. Not a one. But they say that that doesn't matter because they feel like it was an insurrection. It's really, really feeling that way. We've got Rocky says, is not insurrection a clearly defined legal term? How can a lawsuit trying to keep Trump off the ballot be allowed to continue with undeniable lies? Confused. I mean, I know the system is bad, but, well, just to zoom out on this, like anybody can file a lawsuit for any reason. You can just file it. It can be the worst lawsuit ever. And you can still win. If nobody objects to it, you can win by default. So anybody can file anything, and that's where we're at right now. So this lawsuit, hopefully is dismissed, but maybe it won't be. Maybe some judge somewhere takes a look at a lawsuit like this and gives it some wings. That's the scary thought. We got Dolphin Fan is the man, bringing in Adam K, Paulie S, One Nation Underground. We got Clyde B, we got Greg E coming in because Dolphin Fan is the man. Thank you very much, Dolphin. I appreciate you there. We got Tony Hay also bringing in 5 new members. Man, our morning streams are going to be pretty lit. We got this one, Rogue Rose coming in, Dano's coming in. Stop sniffing kids, Joe. Welcome aboard. Jason H is coming in along with John C. Good to see you guys. And thank you, Tony Hay, for bringing in 5 new members. Going to be fun. Grab the Telegram link for our after party. Tree Bark says, great show as always. Thank you, Tree Bark. And thanks for being a Locals member. And thanks for sending in the dono. We got Woods Precision Arms says, can the Supreme Court step in and squash these unconstitutional criminal charges? They could, yeah. So the answer to this, can the Supreme Court do it, is almost always yes. The question is, will they, is almost always no. You have to, petition to them, and you'd have to have a good basis for it. And so it depends on what the claim is. And I don't know that I'm very optimistic about it, to be perfectly honest with you. We'll see. We'll see what they do. But they could. Will they? I doubt it. PWJDLLM, LLM in the house, says, can you play the video I posted to community? Gangster News Trump rolling up in Fulton County. Maybe in the after party, PW. Let's take a look at it. Sometimes I play videos, sometimes I don't. Depends on the content, depends on the music. Sometimes, videos can be a little squirrely because some people like what's in the content, other people don't. If there's profanity, if there's music, I get copyright problems on YouTube. So videos are always a questionable thing. So it depends. We'll take a look at it though on the after party. And PWJDLLM, man, LLM, that's like smart. It's like a smart person. All right, be careful when you see LLMs. They're smart people. We got this old guy. Says, yeah, but Section 1 of the 14th Amendment says specifically, no state shall make or enforce any law that shall abridge the privileges or immunity, nor deprive any person of life, liberty, property without due process, or deny anybody equal protection. So don't buy that argument that it automatically works. Indictment doesn't equal guilty. Yeah, I agree with that too. And I think that even the conviction, even if he is guilty, how does that fall within the insurrection clause? He hasn't been charged with insurrection in any way, shape, or form. He hasn't even been charged with seditious conspiracy. Trump hasn't even been charged with sedition. Not even sedition. We got C. John bringing in 5 new members. Catania Mama Italia coming in. Good to see you, Catania. We got Charmilly, Charmay Lily, Aha, Keister Bunnies in the house, and Trevor L. all coming in thanks to C. John in the house. P-Dub says, thanks, only let's tip $1. Well, I don't know what's going on over there. All right, P-Dub, we'll check that out in a minute. Teeny BB says, thank you, Rob, for all you do. You are awesome. First watched you review Kyle Rittenhouse's trial. Also, bestest chat friends here. No doubt, we got the best chat ever. Aloha. Aloha back to you, Teeny BB. Hope you're doing good over there. And man, that's been a while. Yeah, Kyle Rittenhouse was one of the first ones. And that's when I even knew less about what I was doing on YouTube. So we've made some progress. Still working on it. But first super chat from Teeny BB. Thank you, Teeny BB. Really appreciate you being here. and for the support. Thanks again. We got Tony Hay says, it would be funny if Trump went on the run and at his rally, he would say, "Make America great again. I gotta go." Because like the police, like Fanny's sirens are coming, big Fanny's like on the bullhorn. Get back here, Trump, or something like that. Is that why? I don't know. Trust Two Kids says, too many disgraceful judges and lawyers. Thanks for the stream, Rob. Thank you, Trust. Good to see you over on Rumble. Appreciate your dono and your support. Man, it is a rough one. Yeah, today was a rough one, no doubt. Hey, P-Dub says, first time it showed on bar to change amount, LOL. So P-Dub is experiencing our locals technical thrill ride, which is a lot of fun because you never really know what you're going to get sometimes. Sometimes it's like perfectly functional, and other times they think you don't really need that feature. So thanks for continuing to push through it, JD. LLM in the house. And thanks for making it happen. Music Micro Gaming with another one. Thank you, Music. We had this one from Jack Mack. Says, it's so hard to stay optimistic at this point. It is a little bit hard. It is a little bit hard. I can relate to that. I can relate to that, Jack Mack. It's like, wow, what a joke. I thought that we had some people that were at least moderately integrous, had moderate amounts of integrity. But I'm having a lot more doubts about it. That being said, every time there's one of these new things, you're like, wow, I can't believe it's that corrupt. We're all having that revelation together. We're all going through it together. It's like, wow, the judge actually made her ruling based on the organization from the government prosecutors. I joke about it as being a highlighter, but that's what it is. It's like they're very organized, so you don't need to review the discovery. It's an insane legal argument, but it's where we're at. The silver lining, these people are telling us who they are, and we have to know about who they are before we can do anything about it. Crash to Contrary says, Rob, the typo lawyer. We'll leave that one aside. We'll come back to that one. Chapa says, isn't this democracy at work? The right has voted to move on, and the left has voted to prosecute. All the while, our constitutional republic dies. All the while, our constitutional republic dies. They say that they're doing this in the name of democracy. They're saving democracy by preventing us from not voting for our candidates. Isn't that nice? Don't you feel safer and saved now that you don't have choices? Because if you had a choice, you might pick somebody that they don't want you to pick. Yeah, that's what they think. All right, let's say hello to our friends on X before we jump over to our members only after party. Who is over here? Ooh, we got the C-SPAN review. Says this is absolutely disgusting what the government has done to the rule of law. No doubt. Danny McWilliams says, what a screwed up world we live in. Fred says, Rob, whatever happened to 3 girlies? Shout out to the youngest girlies, who's a member on our locals community, who's great. She's there. We saw her, I think, yesterday. Fred says, guilty until proven innocent. Al Holman says, I say let the court rule now on the 14th, so we go to SCOTUS sooner. Yeah, that's one way to do it. Like, let's just hash it out. Let's go see what you say. I think they're going to try to keep him off the tickets, man. It's crazy. James is here, says, can Trump appeal the trial date for discovery to the appellate court and also prove it is interference to the election? We'll see if he does. I think technically the answer is no, right? Like most criminal filings you deal with at the end of the criminal case. He may do it. He may file something. We'll see. But I don't know what they'll do. Ali G. Alf Bicknell is here. This person has a very interesting take. We'll leave that one there. All right. So we've got, my friends, that's our friends over on X, and we are going to leave it there. We're going over to our members only after party at watchingthewatchers.locals.com. And we would love to see you join us over there so that we can hang out for a bit and do a final debrief. Final reminder that we have a new website called robertgovea.com. We'd love it if you checked it out. Signed up for our daily newsletter. So if you miss anything here, you'll get a summary of everything that we covered delivered to your inbox every morning, the day after the show. And we would love to see you over there. Hey, Elizabeth C. Thank you very much, Elizabeth. Thanks for sending this one in. The Maraca guy. I dig it. Thank you very much for sending that one in with that lovely support. And another one from Music Micro Gaming Mix. all in the house. We are going over, my friends, to watchingthewatchers.locals.com. We're going to hang out there for a little bit. You can get your Field of Greens at fieldofgreens.com, courtesy of our friends at Field of Greens. Save 15% off with code Robert when you check out. Shout outs to our mods and our meme smiths, our friend Vienti Kiss, K Bean, we got Just Cause, Playing Hooky, our friend Ronnie, Zulu, Beyond Geo, Zach Nichols, John Allen, Jan X here, Dog Digger, Donut Mind Me, John McGarvey, our meme smith, Sleepy Dog Lee, Jigum Geegum, Nathan, N810. And we got the best mods, we got the best meme smiths, we got the best chat, we got the best community. We're so grateful for everybody being here and joining us. It has been a Monday indeed, and I think we are getting started here. It's going to start picking up now that we've got trials scheduled in a couple months. And so we'll be back here tomorrow, my friends, to do it all again. I hope to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. I'll see you right back here tomorrow. Bye-bye.